హలో హలో, వాయిస్ వస్తుందా చూడు. అడవి ఎందుకు చేస్తున్నాడు ఇంకలంత విషయం. హలో పెట్టన్నా నేరుగా పెట్టాలంటే అన్ని కొంచెం చెన్నై దింపుతాను చెన్నై సార్ చెన్నై దింపి డోర్లు ఏమని చెప్పు. ఏసీ వేస్ట్ అవుతుంది, ఏం ఆటలు కరెంట్ బిల్ ఎవడు కడతాడు.
పైకి రాను అంటే పైకి రా పని ఎట్లా అంటే లాస్ట్ ఆన్ చేయకుండా నీళ్ళని పోతాయి అంటారు మనకే ఇట్లా రివర్స్ నీళ్ళని పోతాయి ఆన్ చేయకుండా ఇంట్రెస్టెడ్ వీడియో ఉంటావా వీడియో షేర్ చేసుకోవచ్చు ఏం వీడియో మొన్న ఉన్నాం కదా ఏం లేదు ఊరికే ఊరుకో ఉన్నాం ఊరికే కూర్చోని ఉన్నాం తప్ప అందుకే ఆశలు వెళ్ళిపోయి పడుతుంది రెండో పీరియడ్ పోయేసరికి క్లాస్ ఆ పీరియడ్ పక్కగా ఆశలు వెళ్ళిపోతుంది ఎవరు ఉన్నారు ఆ పీరియడ్ సార్ మేడం కూడా లేరంట చెన్నై మేడం కూడా లేదు సెకండ్ పీరియడ్ పోతా ఎవరైనా అంటే అట్లా పోయి మోడల్ పవన్ ఫస్ట్ పీరియడ్ క్లాస్ లేకపోండి అంటారు ఇప్పుడు ఆయన వస్తాడు ఇది క్లాస్ లో సిస్టమ్ కావాలంటే అడుగుతాడు
ಫಸ್ಟ್ ರೋಲ್ ಸಿಗ್ನಲ್ ಕಾರ್ತಿಕ್ ಬರ್ತದ ಮತ್ತೆ ಸಿಗ್ನಲ್ ಸಿಗ್ನಲ್ పడతాను బ్యాగ్ ఆ బ్యాగ్ తెచ్చి మళ్ళీ మేనేజ్ వచ్చి
డెసిమల్ అంటే తిరిగి ఎప్పుడు కూడా మళ్ళీ కావాలి
బాగుందా
పెట్టుకో ఒకరి మీద ఒకరు చూడకుండా బయట చాలా మంది దగ్గర పెట్టుకోవాలి ఒకరి దగ్గర పెట్టుకోండి మనం చేయకపోతే దూతా ఉంటాయి నడవకపోతే దూతా ఉంటాయి
అవుట్ రావట్లేదా
వస్తానే ఉంటావా ఏం పని నువ్వే కదా నా కాలేజీకి పెట్టి ఆయన ఫింగర్స్ పెట్టాను
నేను ఫోటోలు తీసుకుంటూ కూర్చున్నాడు అబ్బాయి ఫోటోలు ఫోటోలు తీసుకుంటూ నేను నా పోయేసి పోయేసి వాళ్ళ
Mohan, it is facing somewhere else. I don't know, like it is facing somewhere else. It is facing, go facing the other side, so accordingly you can be. Thank you. Good morning to all. Good morning. Shall we begin? So what were we discussing last class? When was with plaint and how to draft a plaint? Yes. So what all are the things that you have to keep in mind while drafting a plaint? Could you please be louder? Heading, title, with example. Illustrate with an example, like tell me with an example. Before the honorable, whatever court it is, then comes what? What kind of petition it is, whether it is an original suit or whether it's an original petition, whatever it is, then quick, parties, name of the parties, then yeah, under what rule you are filing it, then Then comes the plaintiff details and their description, everything. Then comes the notice sentence. All processes notices has to be sent to the above mentioned address or to the council if we may engage. Then comes the defendants, their description. Then the plaintiff begs to submit and follows. Then goes to the body of the plaint. In the body, initially you have to mention about the relationship and what was the relationship between the parties and how did they enter into contract, whatever their status is. Then go to the dispute, what was the dispute, actual dispute between the parties, then the cause of action, then the prayer, the valuation, then prayer, verification, then list of documents, then affidavit. So this is the set of a plaint. Is it plain? Na doubt irukadilla? No. Now we can file a written statement. What does actually a written statement means? Yes? Pleadings of the defendants or the reply that he has to give for the plaint is called the written statement. Under what order are we filing written statement? Order 8 of Code of Civil Procedure. Now, they institute a suit by presenting a plaint, and once the plaint is presented, it will be heard in the court, it will be admitted in the court. Admit pannadukku appuram, you will be given a posting date. Okay. And process along you after getting process, you will be served with the order of the copy of the plaint as well as order of the court to present before the court on a specified date. Now what happens? You don't appear on the court on a specified date. What is the importance of filing wakalat then? And within then we have to find the written statement as the initial proceedings. Once you get the memo or process memo, that is summoning memo, you have to approach before the court because our hearing date on that specified date will be posted for the appearance of the defendant. On appearing, either you can appear on behalf of the, you should appear on behalf of the, sorry, he will be represented by a advocate by presentation of a wakalat. I will give you a wakalat form. I cannot show you since there is no PPT. I will give you a copy in the drafting record also. I will be giving you how to draft how a wakalat looks. So on the hearing date, the defendant has to appear on the specified date. Or if you are failing to appear, what are the consequences? We will learn later. Now, after appearance, within 3 months, within 30 days, you will be given an opportunity to file the pleadings or the whatever written statement you have to file. First, you will be given a 30 days time period, which may extend to 90 days. You know the provisions for extension of dates for adjournments. One is 151, inherent power of the code of civil codes. As per 151, the court has power to give can extend time. Next is for enlargement of time is under section 148 of CPC. So these are the provisions for which even after the expiry of 30 days and even after the expiry of 90 days, you can approach the court, but it is in the discretion of the court. The court may or may not allow that specified time period. Now what happens is, you were given 30 days time period, which was extended to 90 days, and you have filed even petitions under 151. You have filed petitions seeking time for enlargement of time under section 148, and then also you are not filing written statement. What happens then? You will be set ex parte. What do you mean by set ex parte? What is the consequences of setting the defendant ex parte? Yes? The meaning of ex parte is the court presumes that I have heard you, I have heard the defendant, and in their absence, the court will pronounce judgment in favoring the plaintiff. And it is presumed that the court has actually heard you. But in fact, they have not heard you, but it is presumption that they have heard you, and in your absence, judgment may be passed against you. Okay. That doesn't mean whatever the claim the plaintiff has arose will be awarded, will be given, but court will, without hearing your arguments, without hearing your objections, court will pass judgments against your petitions, whatever. So that is the consequence. If you don't appear, even if you don't appear also, you will be set ex parte, and even if you appear and if you fail to file the written statement with a specified time period, which is as per procedure, it is initially 30 days, which may extend to 90 days, and you can also file enlargement petition under section 148, and even by using the inherent power, court's inherent power under section 151 also. Even then, you don't file the written statement, you will be set ex parte. This is the consequence if you don't appear or if you don't file the written statement within the specified time period. Clear? Clear? Yes, sir. Now, so what actually we do in a written statement? We set out our defenses. We set out why the plaint is not maintainable, why it is, the reasons why it is voidable, or why what is the transaction we entered this for, whatever defense we claim we wanted to submit before the court has to be submitted in the form of written statement alone and no other. Whatever defenses we want to raise as defendants in the case at hand has to be submitted in the form of written statement alone and not other. But suppose after the institution of plaint and you have filed the written statement, and after filing written statement there is some new cause of action or something, some knowledge you got about the transaction or something new has arose, then there is a rule that you cannot raise any defense after filing the written statement. What is the remedy available to you? You have filed the written statement, thereafter only came to know about some new cause of action or something new has come into your knowledge. Now what is your remedy available to you? It's not plaint, I am asking about the written statement. One remedy for the plaintiff is amendment of plaint. Likewise, what is the remedy available to the defendants? It is called replication. If suppose, for example, after institution of the plaint, there was a new cause of action or something, new information was there. He filed an additional, he amended the plaint and filed a new amended plaint has been filed. And for the original plaint, we have already filed the written statement. So, in order to raise our defense with regard to the amended plaint, we will find the additional statement. This additional statement is what we call the replication. Clear? So, even after, if you submit the written statement and something new allegations has been raised or arguments has been raised by the plaintiff, so in order to counter their arguments, we can file in the form of replication. Our arguments in the form of replication. After that, no other, but it is all in the discretion of the court. The court may or may not allow. Understood? Even if you want to amend the plaint, you have to submit first an application to allow for the amendment. Then the court will give you a stipulated time period within which you have to file the amendment. Once they file the amended plaint, you will be given an opportunity to defend it. That defense is called replication. Filing a new statement, additional statement. Clear? Idea kadachada? Now, yes? Plaint additional, suppose there is a, after filing plaint and written statement also being filed, defense has also been filed in regard to the plaint. And the original plaint filed pannadukku appuram, there was something new information or knowledge has come to the plaintiff. So plaintiff will file will amend the plaint and he will file an additional plaint. In the additional plaint, he has to give the defense right. If you don't deny it, what does it mean? That is admitting their proposition. They are admitting their contentions. So for the amended plaint, we have to file a defense, and that defense we will file in the form of replication. That additional statement madri file pannalum porum. Or like in amendment, what we will do actually, in amending of plaint, we will file a petition. Along with the petition, we will file an affidavit, and the affidavit we will state in detail. In paragraph 3 or paragraph 4, in the line we are adding the statement, and that petition first we have to submit. That petition has to be allowed. Then only we have to, from the beginning, we have to file the copy of the amended plaint, that is with the amended contentions also. Fresh plaint, full plaint file panna. While only for allowing, you have to and the ennalla namakku add pannanumo adu mattum add pannalam. Understood? For example, even in the case of while suit is continuing, if one of the person dies, while you want to implead the party to a suit, pudusa fresh up, if you want to implead the parties also, and the party array add pandrathu kuda, we can add as in the form pudhiya fresh, I mean we will file an IA for impleading the parties. After impleadment, the amended mari copy file pannalam. Understood? So far, is it clear? Now we will go into the rules and regulations with regard to the while filing a written statement. First one is, so as I stated earlier, as per order 8 rule 1, on copy of receiving the summons within 30 days, you have to file the statement, which will be extended to 90 days. 148 to as per 148 and as per 151 namukku power irukku, that I told out idil illatha sollen. This is not given there in the order section, but I am telling you out of it. Is as per 148 and 151 also you can ask for extension of time. Then what happens is, if you have any kind of specific pleading or new pleading, it should be specifically pleaded. Ennavadu pleadings irukuduna, you have to specifically plead, and apdi plead pannalana, the court will take it, you have not pleaded, adu raise pannatha mari. If you vaguely if you vaguely tell and go, the court will not accept such kind of arguments. You should specifically plead whatever arguments that you raise. First thing. Second thing is, the denial must be specific, because statement ஆரம்பிக்கிறதே இப்படிதான். As I told, like before the honorable so and so court, OS number so and so, plaintiff, their description, இங்க notice service அப்படி சொல்ல தேவையில்லை. Next, defendants so and so, then written statement submitted by the defendants as per section, as per order 8 rule 1 of code of CPC. So this is how what the cost title and everything. Now the first paragraph is very important. Here the actual job of the defendant is denial. Whatever the contention, maybe you will first, that is why I told you the plaint and everything, your arguments has to be numbered for the purpose of denial. Maybe in the first paragraph in the plaint, it will be stated the plaintiff and defendants are siblings. As per partition deed number so and so, we got the property so and so, everything. Maybe you as a defendant might admit those facts. So the defendants are admitting defendants are admitting the contentions raised by the plaintiff in paragraph 1, 2 or 3, whatever it is. If you are admitting, you can do like that. Then if you, most importantly, when you start a written statement, should be that this suit is not maintainable. That should be the first sentence. Like the suit is not maintainable either under law or on facts. இது ஒரு மந்திரா மாதிரி படிச்சு வச்சுக்கோங்க. எல்லா written statementல எழுதணும். It has to be there. The suit is not maintainable either under law or on facts. Then what next sentence? And in what kind of suit was actually filed by the person? The plaintiff has filed a suit for injunction, or it is for filed a suit for setting aside a sale deed or whatever. As என்ன purpose the plaintiff and the suit file பண்ணிருக்காங்களோ, that should be specific. given like 2 or 3 sentences, what was the actual reason the plaint has been filed. First sentence is the suit is not maintainable either under law or in facts. The plaintiff has filed the suit, above mentioned suit, for maybe for example for injunction, suit for injunction. And what you have to do, அதுவே நம்ம interpret பண்ணிரதெல்லாம். They have filed the suit by suppressing the material facts, by misleading the court. Okay, so these are the terms that you can use. The plaintiff has filed the suit by suppressing the material facts and in order to mislead the court. Then you have to mention other important sentence. All the arguments and allegations raised by the plaintiffs are denied by the defendants, except those are specifically admitted. First, a full denial. First, you have to give a total denial stating that all arguments and allegations in the plaint, except that are specifically admitted or dealt hereunder, are opposed to facts, law, and evidence and are denied by the defendants. So, in the paragraph has to be there. Clear? Is it clear? Yes or no? So first is you have to file and the statement that the suit is not maintainable either under law or on facts. Then what was the reason the plaintiff has filed the suit? If it is whatever it is, if it is an injunction, the plaintiff has filed the injunction suit by suppressing material facts and for misleading the court, then you have to write all the arguments or allegations raised by the contended by the plaintiff is denied. That the full denial except those who are specifically admitted and it is against and is opposed to fact, law, and evidence. This has to be there no matter what. This has to be there. Okay, this is the introductory paragraph. Next, what you have to do after the introduction, what is the next thing? Number of facts. அவங்க ஒரு set of facts சொல்லியிருப்பாங்க, which may be true, which may not, which you want to admit, which you don't want to. Now you can go into the fact of the case. Like if it is for suppose for an injunction, like if it is a dispute with regard to pathway, and he wanted to obtain an injunction against me so that I don't use that pathway. This is a hypothetical situation. Say, how you have to start now? What all things are there? Fact, there is a right. He presumes that he got a right, maybe easement right, whatever it is, and there is a pathway. So it is mandatory that there should be a schedule. And what was the relationship between the party? Are they neighbors or whatever it is? And that those details has to be specifically mentioned. So first thing, I'm giving this hypothetical problem. ஒரு pathway regarding the pathway describe பண்ணணும், or how is for what purpose you using that pathway for? அவனோட residential purpose க்கா இல்ல அவங்க vehicular purpose க்கா, whatever it is, அதை யூஸ் பண்றாங்க, and what was the necessity and how long he has been using it. So whatever things you are admit counts. Okay, so a description of the property or whatever it is, your case law, then your case, then what? Now you can go into their plaint. Mother number fact solli mudichu. First is our total denial. Second is our facts. What is our story? Second, then what happened? But each and everything has to be numbered. Okay, though even if we are telling our story, doesn't mean it should be in the single paragraph. You can do it as per your convenience. Story eppadi pogudu adhe mari you can conveniently do it. Then comes what? Denial. That is very, very important. The arguments contained in paragraph 1 to 3 other eppadi vena nam arrange pannikom 1 to 3 in respect of whatever blah 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 is being denied. The denied mattu solla kudadu. You have to state the reason, not the law, but you have to state the reason why you are denied. That is very important. Evasively, you cannot deny your contention. As per order 8 rule 4, evasive denial. முடியாது. What do you mean by evasive? Vague, indirectly, indirectly சொல்லக்கூடாது. Whatever denial you are giving, it should be directly given. Okay, so that is also very important. So what நீங்க அந்த அந்த plaintiff list, there are 20 paragraphs. You are supposed to deny all the 20 contentions. Okay, is it clear? Now what happens? So the first thing is what? If you want to plead, that is what I told. If you want to unga story illa ungalku plead pananona, it should be specifically pleaded. Okay, that has to be there. Then this denial must be very specific. It should not be evasive. Evasive denial will not be other denial எடுத்துக்க மாட்டாங்க. Yeah, and it has to be very specific, and you should deny with reason. You should state your reason why you are denying it, and that is with regard to introduction. So far is it clear? Yes or no? First is the name of the court, the case number. By then you will get the case number. Nama OS plaintiff file பண்ணும்போது OS dash of 2023 வரும். Once you get the notice, you will get along with the case number, right? So OS dash of years, plaintiff details, defendants details, written statement most respectfully submitted by the defendants, or you can submitted by the defendant counsel, whatever it is. Avanga style madri, every counsel has their own style of writing. Under order 8 rule 1 of CPC. Then the first paragraph, the suit is not maintainable under law of fact. Then what is the actual suit? Is it what kind of suit it is, and what is actually they have done in the suit? They used to say it is misleading the court, it is suppressing their material facts, they have not come with clean hands, blah blah blah. Konjo terminologies ella irukku. Then what? You have to first total denial has to be there, that it is not, and is the defendant denies the contentions raised by the plaintiff in the plaint, and it's opposed to law, facts and evidence. Then you have to start with your story. That story ungaloda reason enna adukaprom, then starts your denial, and your denial has to be very very specific. Mudinja ellam deny padu. You might sound very boring. The vasiki, what is he doing? They apply copy paste panni deny pandranga, but it is that is what you have to do. But make sure you deny with your reason. Evasive denial is not allowed. You should be, and it has to be specific. And what after here? Then what happens? That will come separately. Then we are concluding. That what will be your conclusion? Therefore, the defendant submits that the suit has to be dismissed at the cost of the defendants, at the cost of our defendants. And if there is a description, the property description, schedule description has to be there, and also like deponent sign and verification also be everything has to be said there. So this is the model with regard to written statement. Suppose you know the difference between set of and counterclaim. Yes. So, for example, in the injunction suit le ungalku or allegation irukku avanga mara, what you can do is, instead of filing a separate suit, that is the purpose of counterclaim, you can file a counterclaim in the same suit like a plaint itself. So what you have to do is, while drafting the written statement, you have to draft in such a style that towards the end it looks like a plaint. So you got what I'm telling. If you have your ungalku or contention irukku, instead of filing a separate suit for that your contention, since it is the same cause of action against the same parties and within the pecuniary jurisdiction, that also has to be seen. And with regard to the same subject matter, everything is same. So it is okay that you file a counter claim. So what people now we have mentally drafted a written statement, right? So initially மாறுறது ஒரே ஒரு விஷயம் தான். In giving the cause title, written statements along with counter claim. So what is the provision will change? Order Order 8 Rule 1 read with 6A. 6A has also to be mentioned. 6A is with regard to the counter claim. And so likewise you can draft உங்கள allegations எல்லாம் சொல்லிட்டு by then நம்ம written statement just எப்படி முடிச்சோம், we didn't ask for any prayer, there was no valuation, we didn't write any kind of cause of action, and where there was one list of documents, nothing was given. Statement மட்டும் file பண்ணணும். What was the statement? That was just the denial. Now if you wanted to file a counter claim, you have to எப்படியெல்லாம் plaintsல நம்ம file பண்ணோமோ, starting with cause of action, valuation, schedule, list of documents, everything has to file, and verification of the deponent and as well as the affidavit for supporting his claim. So when you file a written statement in the form of counter claim, it would be treated as a plaint itself. So here what the what is it? Plaintiff will also be given an opportunity to file the counter for the reply for the counter as well. Okay. So there is actually two suits here, but clubbed together in the form of plaint and counter claim. Clear? Is it clear? Yes. Yeah. But they will be in the they will continue as plaintiff and defendant alone. But while they're arguing in the counter claim, and likewise they would argue. Suppose, for example, very good. If the plaintiff, after institution of the suit, the defendant has filed the statement along with the counter claim. Now the plaintiff fails to appear before the court. Normally, what happens if the plaintiff fails to appear before the court? The suit will be dismissed. But the suit will be dismissed only with regard to the plaintiff's averments. That counter claim, what happens is it will transpose. Now it will be transposed and he will be set ex parte. Got the idea? Then the counter claim would stand as a plaint, and since he is not appearing, he will be set ex parte as if he was a defendant, and you will be given an award ex parte, decree will be given to you. Got the idea? So far as clear. Tomorrow I will give you a hypothetical situation so that you can try to draft. Try to draft just on the format correct and challenge yourself. You can create your counter claim. What set off na set off? What if in case of set off? Set off na only in the case of money suit. Only in the case of money suit you can claim for a set off. And set off பண்ணும்போது you should specifically mention what was a liquidated sum of money and all those transactions that I will explain in the next class with regard to set off and counter claim. Is it clear? So இன்னைக்கு என்ன டவுட் இருக்கா? Clear. Thank you guys. Thank you.
All right, the next topic. Okay. Good morning, students. Silence. So we have seen the classification of advocates into two groups, which is senior advocates and other advocates. And we have also seen the aspect of this classification is reasonable, and the challenge of constitutionality, or it passes the test of constitutionality. Now there is another factor which we need to see is nothing other than the right of pre-audience. Note it down, the right of pre-audience, P-R-E-A-U-D-I-E-N-C, right of pre-audience, comes within the purview of section 23 of the Advocates Act. Section 23, right to pre-audience. So this right to pre-audience is none other than, okay, right to pre-audience is a superior right to be heard. It's a superior right to be heard. It's a superior right to be heard, who are mentioned in this particular section itself, on the basis. I myself is a electromagnet, maybe. Okay. So this superior right to those advocates who are mentioned in this particular section, according to this hierarchy that is mentioned in this particular section, in this section, maybe now it's clear. So based on this hierarchy, which is the persons who are mentioned under this section, they will be given pre-audience. That is none other than an accommodation given in the court to the lawyers. So the certain lawyers will be there. If there is a senior sitting in front of the court, naturally he will be given a priority to be heard. That is what pre-audience, right to pre-audience, is dealt under section 23. Please refer to section 23. Now pre-audience, the term pre-audience is none other than right to be heard before the other. Right to be heard before any other person. Right to be heard before any other person. Now this is a privilege. This is none other than a privilege to be heard first. To be heard first. Who will have all these privileges? Based according to those persons who are mentioned under the section itself. Refer to the section. We will go with the section again. Now this right to the lawyers, whereby if I am coming in the hierarchy first, I will be given the first priority to speak or to address the bench. The bench and the bar. Again, it's a very important question. In a part B, what is the bar and bench relation? What do you mean by bar and bench? What is the relationship between bar and the bench? We will discuss that if time prevails. Now the preference at the bar among all other lawyers or legal officers or advocate. Why legal officers? Why? Because there are legal officers of the court, of the state also, who may be addressing the court. Then in such cases, the first person who will be sitting there, who is according to the hierarchy, he will be given this particular preference. Now, this particular pre-audience puts the person who has a right to pre-audience above all the others who are in hierarchy under him. Okay, the same category has to be established in his authority. Now, please, okay, let us see section 25. Can I declare? Please, see section 25 of the Advocates Act. Who all will be the persons who are designated in accordance to section 23 to have the right of pre-audience? That's my mobile phone. A right of pre-audience. Random. Attorney General of India will have right of pre-audience first. So if Attorney General is there in the court, he will be given the opportunity to present his case first. That is Attorney General, pre-audience will be there. Now, Attorney General of India, his position is none other than a constitutional position. Okay, he is elected by the President of India under Article 76 of the Indian Constitution. So he is again assisted by Solicitor General of India. He is assisted by Solicitor General of India. Now again, so first one is none other than Attorney General of India. Second one is Solicitor General of India. Solicitor General of India. He is the second law officer of the country. He is the second law officer of the country. Another person who should be given priority is none other than the Attorney General. Then comes the second person who is assisting him, who is none other than the second or law officer of India, who is again Solicitor General. Attorney General is none other than a person who is the chief officer, Government of India Chief Legal Advisor. So refer to Article 76 of the Indian Constitution to know more about Attorney General of India. Again, section 23 says that Attorney General will be given pre-audience first. Second one is none other than the Solicitor General. Now, Attorney General, second Solicitor General, third is Advocate General of any state. Advocate General of any state. So each and every states will have its own advocate. Okay, Advocate General. Now this Advocate General will have this Advocate General. Okay. Take it away. Take it away. No, I will speak with this. No, this is okay. Yeah, this is it. So the third person is none other than Advocate General. Now, Advocate General of any state will have pre-audience subject to the rights of the other twos, that is the Attorney General and Solicitor General of India. I don't need mic, I think. Maybe. Then comes designated senior, which we have discussed yesterday. The fourth one is none other than the designated seniors, which we have seen yesterday, who all are being appointed by the High Court or the Supreme Court in accordance to the names which is selected by the panel, that is the permanent committee of the bar councils, based on their quality and qualification, experience, standing of practice in the bar. So the fourth one is none other than the senior advocate shall have pre-audience over all other advocates. And the fifth one is right of pre-audience to senior advocates. among them, inter se, among all others. Other advocates inter se shall determine their seniority respectively. Based on my, say I am a fresher, I am a junior. So if there is a senior to me in my in the court, naturally I will give he will be have to be given a priority to be heard. That's the priority, or that is the pre-audience system that we can see here. The nature and scope of this section 23 has been dealt in, noted down, Tikka versus TIKA, Tikka versus state of Uttar Pradesh. TIKA, Tikka versus state of Uttar Pradesh, 1975, Criminal Law Journal, CRLJ, Criminal Law Journal, 335. Now, merely determining the rights of an advocates inter se among themselves to be to the right of pre-audience of the court is based on seniority. The question of seniority will be determined between themselves. Whether I am senior or he is senior, not based on my age factor, but on the based of the seniority of standing in practice. Okay. That is with all with relating to right to pre-audience. Again, part A question may be asked, what is right to pre-audience? Okay, that's all. Now, next thing which we need to, next topic which we need to discuss is, yes, bar and bench relation. Part B question, bar bench relation. What do you mean by bar and bench relation? Now, what do we mean by bar and what do you mean by bench? Now, bar and the bench. Now, by bench, we mean all the judge, they are sitting together, that is the bench. That is distinguished from the bar. What is bar? Bar is none other than the advocates. So, the bench, part of the bench when of the court, when we say bench of the court, it's a part of the court which is considered to be sitting in its official capacity. In its official capacity. Now, what is the main business of the bar and the bench? None other than administration of justice. We have seen the main duty of the lawyers, the advocates, is none other than administration of justice. The duty towards the society, duty towards his client. And again, what are the rights of an advocate? What are the duties of advocate? Part B question. What are the rights and duties of an advocate will be asked as a part B question. Now, with related to bar and bench, again it is coming in within the purview of part B of your university exams. Now, whereas bar applies to advocates, as I told you, bench is that part of the court where in its official capacities judges are sitting for as judge in their official capacity. Whereas the bar is concerned, that is none other than, it is distinguished from the bench, they are advocates. They are also part of the court. They are also part of the court. Administration of justice is one of the pivotal important role played by both of them. Not only by the bench. Administration of justice is not meagerly vested with the bench. It is also a duty to be performed by the bar as well. What is the bar? It is the other part of the court which is consisting of advocates. Now, there should be, now when they are cordially having a relation between, the relation between bar and the bench, there should be a mutual respect between them. Say for example, what if there is a quarrel between the bar and the bench? Will it affect the administration of justice? Naturally, yes. It will definitely affect the case which is before the court. And the court is not simply the bar, but also the bench. The other way also. It is not meagerly the judge, but also the advocate. Because the advocates are none other than the helping hand of justice, without whom the court will not be able to address justice properly. Okay. So there should be a mutual respect which is necessary to maintain this cordial relation between the bar and the bench. There should always be a cordial, smooth may not be a frictionless. It cannot be a frictionless, but as far as possible, a cordial relationship should be maintained between the bar as well as the bench. Now, the judge and advocate are complementary to each other. They are opposite. They are harmoniously dealing with the court procedure with each other. Now, they belong to the same community, they should respect each other. They should speak with morality. This means that not always there will be a smooth functioning of the court. There might be chances that when there will be a heated conversation between the court, the bar and the bench. While again in your moot court practices, when you are going to conduct the moot court on the next coming days, again your concerned teacher would have taught you how to behave yourself in the court. You should behave in a very polite manner. Even if you are posed with a question, you should not behave uncourteously. You should behave very politely. If the court is asking you a point which you as a lawyer forgot to point it out, you should ask pardon to the court about your drawback or what you have not noticed. And you may also ask pardon for the inconvenience caused. So politeness is very important part which has to be played on the part of the advocates. Not only them, can also be a part which is played by the bench as well. Now, sometimes the bar and the bench, their members may have a rough, unworldly clash between them. Now, as far as possible, this clash should be avoided. While they discharge their respective duties, they might get into dialogues. Sometimes heated conversation, harsh, but there should be fair behavior between each other. Okay, the advocate has to put forth his own case, his full effort to persuade the court to verdict a judgment in his favor. So what if I am not successful to do that? I will not argue with the court. I will not behave with him in an unpleasant manner. There is an option given to me. What is that option? Appeal. Isn't it not? If I am failing to get the verdict in my favor, what option is left with me is not to quarrel, but opt for an appeal. I need not quarrel with the court, but I should not be behaving in a rude, impolite manner to the court if it is not favored on my behalf, on my part, to my part. Then I have every option to file an appeal before the court. The case may be won or lost on a daily basis. That doesn't matter. That doesn't matter. What matters is the behavior, because this is my profession. I might win this case, I might lose this case. As this is my profession, tomorrow again I need to come before this court. Obviously, I need to come before this court with another case. If the court is of an expectation that I am a person who is behaving very rudely, discourteously, again, that is a matter of, this behavior is a matter of contempt of court also, against which the court can initiate proceedings against you for contempt of court. What misbehavior, what all will lead to contempt of court, what all will lead to professional negligence on my part, professional misconduct again. These are coming into their essay part. Part C. Part C questions will be dealt with professional misconduct, contempt, professional negligence. What are the proceedings which can be initiated against you? Who all will initiate proceedings against you? All such questions are dealt in the part C question. Okay. Again, who will deal with that will be coming within the purview of part B. Which is the court or who can initiate proceeding against you, an advocate regarding professional misconduct. So one thing you need to remember on the part of an advocate, that is the bar and the bench relation. the bar, that is the advocate, should behave courteously, without aggression, polite manner towards the court. Now, there might be situation when the advocate might have a personal opinion about the court. That should not reflect the case. There might be a situation where the advocate himself will have a personal opinion about the judge who is part of the bench. Again, that should not reflect into the case which I am arguing. That doesn't matter. You might have a personal grudge or vengeance with each other. That should not show in your case when you are arguing the matter. Now, this uncourteous, unpolite, professional misconduct of a lawyer, mind you, it is part of contempt of court. Now, using insulting language to the court, not allowed. What all can be contempt? That is what I am giving you some instance. For example, using insulting or language which is unparliamentary in the court against the judge, not allowed. Then not to use illegal means, etc., to get a case in favor of you. Threatening the judge, threatening him to be transferred from this court to some other court, some other area, again comes within the purview of contempt of court. Then questioning the authority of the court, not the jurisdiction, authority of the court, on what authority he is acting, etc., are also coming within the purview of the professional contempt done by the advocate. Again, making scandalous allegations against the court. Now, this all shall be punished. This all shall be punished. Why is it a sanction being imposed on such a conduct of a lawyer? It is none other than for the smooth functioning of the court. So that the court shall function very smoothly. The administration of justice will be done very smoothly. These all acts which are done by the advocate, that is a bar, shall be considered as contempt by the court, and sanctions shall be imposed on such lawyers. Now, this is all with regarding to bar and bench relation. Today we have seen the part of the pre-audience, then we have seen the bar bench relation. Now let us see a small aspect with regarding to, again, part B question. What are the rights of an advocate? Please note it down. It might not be there. It is not, you cannot find it out clearly from the Advocates Act because there are no such sections which deals with. Please note it down. What are the rights of an advocate? The rights of an advocate, there are many. I will give you few. Right to plead or pleading, P-L-E-A-D-I-N-G, right to plead. Now, whom are you pleading for? You are pleading for your client's right, for the relief of your client, not at all. Right to plead, important right upon whereby he pleads for his client's right to be protected. Right to compounding, C-O-M-P-O-U-N-D-I-N-G, right to compounding, subject to certain restrictions, compounding, subject to certain restriction. Compounding of offenses can be compounded at the instance of 482 CRPC, 482 CRPC, to quash an FIR whereby maybe the matter has been compounded between the parties, settled between the parties. In such cases, the advocate concerned may put for a affidavit on the part of both the parties, and the matter may be compounded, settled, showing that the matter has been settled between the parties. And the High Court, using its inherent power, under section, you might have studied CRPC, 482 CRPC, quash the FIR registered against the accused. Gyan Singh versus State of Punjab. Now, the right to sitting in court, right to sit in a court. An advocate has a right to observe the proceedings of a court, to sit inside a court, to sit inside a court. Who decides who will sit inside my court? I. Who am I? I'm a judge. Isn't it not? Supreme Court, I'm sorry, I forgot the citation. Supreme Court decision is there. Supreme Court decision is there. Tomorrow I will tell you that is citation. So the court has the authority here. The advocate concerned has the right to sit inside a court, not only for his case, but also the case of another. Does that include every time that he can be there? No. The court, if the court says, request him to go in camera proceedings, I cannot insist that I have a right. Professional ethics sir told me that I have a right, so I will be here no matter what. You will be in trouble. I may not come to help you because I don't have an authority. So, right to sit inside the court, not only for his own case but also case of others. It is again limited, like what we have seen in compounding. What as the initial class I have told you, compounding, settling the matter between the parties. An authority should be expressly given by the client. What if not expressly given? If not, then it should be done in a good faith by the lawyer concerned. Now, right to inspection, right to inspection, inspect what? Inspect documents in the interest of his client. Inspect the documents in the interest of his client. Then right to receive copy, right to receive copy, all documents on behalf of his client. He may receive copies of these documents, certificates, etc. on behalf of his client. Again, it is solely for the purpose of the interest to protect the interest of his client. Next, right to be appointed as commissioner. Right to be appointed as commissioner. Advocate commission, you might have heard about it. Advocate commission, that is one sources of income which you may get as budding lawyers. If you go sit in a court and you are continuously going to one court and the court is familiar with you and you are a junior and your name is there in the advocate commission list, the court may ask you, are you willing to go for a commission? Depending on that, that court may give you a commission. Advocate commission, I presume you all know what is advocate commission. Advocate commission, the plaintiff may appoint a commission to inspect the property. The court cannot see. Can the court see anything? No, the court cannot see anything. It's blind. The court sees through advocates, lawyers. Whatever you tell them, I can understand. So the problem that herein the court may appoint a commission, so that the commissioner will go there, advocate commission will go there and see the matter with his own eyes, take notice of whatever is mentioned in the advocate commission petition. I presume it is in your drafting, pleading, conveyance record. Advocate commission, petition for an advocate commission, and the prayer will be written. Please go through that. Please go through those. As I told you, drafting, pleading, conveyance is very important for you. If you go through that record book itself, you'll be able to know how to write plaint, written statement, petition, everything is there. Legal conveyance in your second part is also very important. Deeds are given, different deeds. If you have a book on conveyance, Mainini, Mortgage, or whatever books you have, it will be very helpful how to write a rental agreement, You can sit in your house and make money out of writing or giving these legal advices and drafting all these aspects. So, right to be appointed as a commissioner is another point. Right to be appointed as a receiver, to be appointed as a receiver of a property, again, is also one of the right vested in you. Right to be appointed as a receiver. Then, right to be appointed as a oath commissioner. Oath, O-A-T-H, oath commissioner. Right to be appointed as a oath commissioner. Depositions, the depositions which are being stated out, mentioned out by the concerned party, say maybe the witness, the commissioner will note down the statements which is given by them in the court itself. As a lawyer, as an advocate, again, seniors may not be given these opportunity. They don't want it also. They don't want it also. You be receiving 5,000 to depending on your state. The commission betta which is given by your state. High Court commission and all would be thousands. I mean 10,000s more than that. DRT in Kerala it is 20,000 rupees. One single commission. One single commission. You visit the place. You take possession of the property. For that, meagerly you will get 20,000 rupees. So I don't want you guys to become a commission lawyer, always going for the part of seeking commission. No, that's not a good way or practice also. Now, appointment of a oath commissioner, then again to be appointed as a notary. Also depending, that's also state rules. Please refer to. So these are all the few rights possessed by advocates. We also need to refer back to what are the duties. So again, part B questions will be asked. What are the rights? Explanation. Meagerly not writing the points. Please explain those also. And what are the duties of an advocate? Rights and duties. With which we wind up. Yes. Please break them.
Hello. Yeah, please. Open. Yeah, please. Please settle down. Right. So we have the different types of acts which govern Arbitration Conciliation Act. One is 1940 Act, another one is 1996 Act. We have seen the basic object behind arbitration. Right now, we have appointed the arbitrator also. Now, the next stage is arbitral award. Right now, once the arbitrator hears all the things, subsequently he is delivering an award. So normally arbitration orders are known as arbitration award. This is the final step in the entire arbitration procedure. Final step in the entire arbitration procedure. Right. Now, once the arbitral tribunal delivers the award, ఒకసారి award ఇచ్చిన తర్వాత the mandate of the arbitral tribunal completes. The mandate of the arbitral tribunal completes. That means it will become functus officio. Functus officio. Once an award has been delivered, finally settling the disputes of the parties, the entire function of the arbitral tribunal will become functus officio. That is, it is no longer in existence. It is no longer in existence. Right. Now, the arbitral tribunal has decided your disputes. After deciding, so many disputes will be there. Let it be a factual dispute or legal disputes. Once it decides the disputes, then it is passing an award. That award is deemed decree. The award என்ன சொல்வாங்கன்னா deemed decree ன்னு சொல்வாங்க. It is nothing but an instrument under which act? Negotiable Instruments Act. Why I am telling you is, Emita, Utesh. No. There is one thing is there. If you don't like the class, you can go out of the class. Don't disturb others. There is something attached to this class. It's not a big issue for you. Right. At least listen. This is the back end of your classes. Listen something. I am not delivering whatever things comes to my mind. Now, I am telling something out of the ambit. Listen to the class. Right. Now, two things will happen. Entire arbitral tribunal will become functus officio. Second one is res judicata effect will come into picture. Res judicata effect means the order which has been made against the parties, it will operate as a res judicata with respect to other disputes. You cannot go to civil courts. You understand? Once you are holding the award, again, while passing the award, it will determine so many issues also, so many decisions also. When arbitral tribunal is sitting, it is deciding so many issues, determine where to sit, place of arbitration, length of arbitration. That means it is making so many decisions also. For example, you are disputing that the seat of arbitration should be somewhere. ನೀವು dispute raise பண்ணுங்க. It is not a seat of arbitration. We want to change the place of arbitration. That issue also arbitral tribunal is deciding. You understand the basic difference between determination of issues and the final award. Final award is the final outcome of the result. Determination of issues means where the arbitral tribunal has to sit. What are the procedural requirements it has to follow? So many things will come. That is also comes under the purview of arbitral tribunal. Arbitral award పాస్ చేయడానికి ముందే ఏం చేస్తారంటే ఎక్కడ కూర్చోవాలి, ఎలా ఎవిడెన్స్ తీసుకోవాలి, ఏమేమి డిసైడ్ చేస్తారు. ఈవెన్ దట్ ఈస్ ఆల్సో determination by the arbitral tribunal. That's why every award is a determination of rules and regulations, but every determination is not an award. You know, every confession is a admission. All admissions are not confessions. Likewise, every arbitral decisions of the tribunal are decisions, but not determinations. Right? Once an award has been passed, it is a instrument under Negotiable Instruments Act. What I am telling you is this award should be stamped with respect to state governments. ఈ ఆర్బిట్రల్ అవార్డ్ వచ్చిన తర్వాత మీరు ఏం చేయాలి అంటే దాని మీద స్టాంప్ డ్యూటీ యూ హ్యావ్ టు పే. ఇఫ్ యూ డోంట్ పే స్టాంప్ డ్యూటీ, then it will render it is an infirmity in the eyes of the law. Why? Arbitral award is nothing but an instrument. Every instrument has to be stamped. Every instrument has to be stamped. Now, once the award has been passed, there are certain effects of the award. Award ఇచ్చిన తర్వాత కొన్ని effects ఉంటుంది. First one is it will conclusively determine the rights and liabilities of the parties. First effect is it will conclusively determine the rights and liabilities of the parties. Next one is disposes of the respective claims of the parties. Whoever is claiming before the arbitral tribunal, it is disposing of the respective claims. Respective claims ఏం చేస్తారు? They will hear the claimant, they will hear the respondent. After hearing both the parties, they are settling your rights and liabilities. First one is it concludes the dispute having res judicata effect. Second one is it concludes with the respective claims of both the parties. That is again award. Third one is again it award may be confirmed by recognition and enforcement. What is meant by recognition? Under our Arbitration Conciliation Act, we are recognizing the foreign awards also. Foreign awards, enforcement of foreign awards. So here, what you can do with this award? Award can be recognized, award can be enforced also. Right. Next one is it may be challenged also. Why I am telling you is while the arbitral tribunal is passing the award, so many interim orders also it will pass, procedural aspects also. Those procedural aspects cannot be challenged, only award can be challenged. Now, within after passing the award, after lapse of 30 days, award becomes a decree in the eyes of the law according to Civil Procedure Code. If the arbitral award has passed an award after expiry of 30 days, it will be able to be a civil decree under section 36 of CPC. Once it becomes a decree, again it is enforceable. Right? Now, award has been passed. Now the Arbitration Conciliation Act recognizes 5 types of awards. First one is final award. First one is final award. Second one, interim or partial award. Interim or partial award. Third one is additional award. Third one is additional award. Fourth one is consent award, otherwise known as agreed award. Last one is default award. Default, yes. These are the different types of awards that are being placed, that has been given recognition under Arbitration Conciliation Act. First one is final award. Right. Here, once final award has been passed, once final award has been given, two things will happen. Pass two things in the eyes of the law. One is terminating the arbitral proceedings entirely. That means once an award has been passed, arbitral tribunal is no longer in existence. అంతే కదా, అవార్డు పాస్ చేసిన తర్వాత ఆర్బిట్రల్ ట్రిబ్యునల్ ఉండదు ఇక్కడ. మనం ఏమంటామంటే ఫంక్టస్ అఫీషియో. రైట్. By passing an award, first situation is entire arbitral tribunal will terminate. Second one is it will settle your disputes and claims. It will settle your disputes and claims. So once final award is passed, two things will happen. One concludes the jurisdiction on the arbitral tribunal. Arbitral tribunal is no longer in existence. It becomes functus officio. Res judicata effect will come into existence. Again, straight away simply you cannot say res judicata. This claim should be settled on the basis of merits of the case. You understand? Merits పైన డిసైడ్ చేస్తే మాత్రమే res judicata effect అనేది వస్తుంది. Simply on the basis of outer evidence, if the arbitral settles or disputes, it cannot be having res judicata effect. That means he has to clearly assess the claimant's claims, respondent claims, then he has to pass an award on the merits of the case. To get the res judicata effect, arbitral award should be based on merits of the case. Then only res judicata effect will comes into existence. So once final award has been passed, it ends the mandate of arbitral tribunal. It will settle the disputes of the claimants and respondents. Right. This is known as final award. Now, the Arbitration Conciliation Act never recognizes interim award. Simply says award includes interim award. Right. Now, interim award means again it is prone to challenge. Interim award means, for example, A went to the arbitration. Right. Now, A has filed a statement of claim. Statement of claim. Now, that means he is having certain claims against the respondent. Arbitration కి ఎందుకు వెళ్తారు? నాకు వీడు డబ్బులు ఇవ్వాలి. He is having certain claims. Now, B is coming and telling that that claim is statute barred. ఆ క్లెయిమ్ అనేది చట్టం దృష్టిలో పోయింది. Why? Limitation Act, he should have claimed this even before Limitation Act. Now, the Limitation Act has come into picture. He cannot claim this claim now. You understand? ఏ వెళ్ళాడు ఆర్బిట్రేటర్ దగ్గరికి ఏం చెప్తున్నాడు, నాకు ఇంత డబ్బులు రావాలి అన్నాడు. he is also telling yes that is true but he cannot come to the court now. Why? Limitation has expired. Limitation ఏమైంది? Expired అయిపోయింది. Now he cannot claim this right before now. Now what arbitral tribunal has to do? First it has to see this question first. Unless and until this question has been settled, it cannot go into the veracity of the claims. Next, first ఏం చేయాలి? ఇది స్టాట్యూట్ బార్డా లేదా డిసైడ్ చేయాలి. అవునా కాదా? డిసైడ్ అయితేనే ఏమవుతుంది? ఆర్బిట్రేటర్ ముందుకి వస్తుంది, లేకపోతే it won't comes to the arbitrator. First he has to see whether this respective claim is statute barred or not. First he has to give a rule on this. Yes, if it is statute barred, you cannot come to arbitration. If it is not statute barred, then you can claim before the respective arbitration. So, whether this is statute barred or chapter law of limitation act, for everything there is time limit is there. Within this time limit only you can go to the courts and file a suit. If time lapses, you cannot go to the suit. For example, promissory note 3 years. Within the 3 years, we have to file a suit. If 3 year lapses, if you go to the court, court will say limitation has expired. Even though you got a right, your remedy has been extinguished, barred by limitation. Everything there is a time limit. You cannot come to the court after 20 years, 30 years. There is some time limit is there. Who prescribes this time limit? There is act is there. For everything there is act. Law of limitation act. Now, you are filing a claim against me. In my opinion, it is statute barred. It is barred by law of limitation. Now, you cannot claim against me. 3 வருஷம் ஆனாட்டு அவன் கோர்ட்ல உங்க மேல கேஸ் ஃபைல் பண்ணான்னு கோர்ட்டுக்கு என்ன சொல்லுவாங்க? இது எடுக்க முடியாது. ஏன்? லிமிடேஷன் எக்ஸ்பயர் 3 years gone. You cannot claim now. Court says you cannot claim now. It has barred. Your right has been extinguished by the statute. Right. Here also, A is going and filing a statement of claim before the arbitration. Now, B is telling that it is statute బార్ అయిపోయింది, నువ్వు క్లెయిమ్ చేయడానికి కుదరదు అంటున్నావు. ఇప్పుడు ఏం చేయాలి? స్ట్రైట్ అవే ఫస్ట్ అన్లెస్ అండ్ అంటిల్ దిస్ క్వశ్చన్ హ్యాస్ టు బి డిసైడెడ్, then only arbitral tribunal can go into the merits of the case. In law also, if any limitation act applies, you have to file condonation of delay petition in the courts. If your condonation of delay petition has been accepted only, subsequent case will be taken to the file. If they reject your condonation application, they cannot go into the veracity of your claims. You understand? First ఇప్పుడు ఏం చేయాలి? ఇది స్టాట్యూట్ బార్ అయిందా లేదా డిసైడ్ చేయాలి. చేస్తే then further proceedings will come into existence. So whatever be the arbitral tribunal is passing an award determining the intervening things, that is known as interim award. Now they are going to decide the questions with respect to what? Whether this claim is statute barred or not. First they have to decide. Again, this is known as not a final award. This is known as an interim award. Right. Once they have to decide this question, then only they can go into the veracity of the main question. So this is another type of award which is recognized in the Arbitration Conciliation Act, interim award, or it is also known as partial award. Right. Now the Supreme Court has said whether interim award has been passed or final award has been passed. ఏదన్నా కావచ్చు. Why? The definition includes, award includes interim award. That's it. Now whether it may be a partial award, whether it may be an interim award, whether it may be a final award, after expiry of 30 days, it becomes a decree under section 36 of CPC. Once it becomes a decree, again it can be executed, enforced as a decree. Understand? So, first, if any question with respect to intervening aspects has come, they will decide the questions first. Then only they will go with the respective claims. So, whatever be the question that has been decided in the intervening period, it is known as partial award or interim awards. Right? Whether interim award or final award, after expiration of 30 days, it becomes a decree. Once it becomes a decree, it is enforceable, executed in the manner prescribed in the CPC. Right. Enna decree anna? What is meant by decree? My students don't tell. I know that you are capable of. What is meant by decree? This side. Huh? What is meant by formal expression? That's what I'm telling you. My students don't tell. Of course, you are all also my students. My students who don't come to class. Huh? Who don't come to class. You know, we are all mortals. Enna mortals anna? Enna mortal anna? One day you are going to die. That is true. இன்னைக்கு செத்தா நாளைக்கு பால். விவேக் டைலாக் இல்லையா? One day you are going to die. That is confirmed. Before dying, achieve something and die. Achieve something and die. But that something cannot be anything. Understand? That something cannot be anything. Die for exact thing. ஏதாவது ஒன்று சாதிச்சு லைஃப்ல டை. Understand? So every day you have to learn something. Movement is life, stagnation is death. If you don't learn today you die. That's it. இன்னைக்கு ஏதாவது புதுசு கத்துக்கலன்னா இன்னைக்கு அவ்வளவுதான். Right. Every day learn something. Right. Now going to third type of award, it is additional award. Additional award. Right. Now you are again, if you challenge the award in the courts of law, can you challenge the award? Yes, under section 34. For patent illegality, erroneous of law, you can challenge the award. So, whenever you are going to the courts and challenging the award, the Supreme Court said to all the courts, always lean in favor of the award only unless and until contrary appears. ఎప్పుడు కూడా మీరు ఏం చేయాలి? అవార్డుకి ఫేవర్ గానే చేయాలి, కానీ ఈ అవార్డ్ ని మీరు ఏం చేయకూడదు? సెట్ అసైడ్ చేయకూడదు. దట్ ఈస్ ద రూల్. To the maximum possible extent, try to give favor towards the award only. Why? Again, if you set aside the award, what happens? Again, they will go before the civil courts and again litigate. Again, so much of time will be wasted. So never what is called lean against the award. Go in favor of the award unless and until contrary appears, means the award is patently illegal if award is against any provisions of the law. Right. Now, additional award means, right, you are raising so many disputes before the arbitral tribunal. Arbitral tribunal. For example, A is there. A went to the arbitral tribunal, file statement of claim. This is the amount I have to get from B. Now, B has come to the court. B is also telling that I need not pay this amount. He is getting what is called filing statement of defense. Right. Now, the arbitral tribunal cannot go out of the ambit of your statements of claim and defense. మీరు ఏమైతే ఆర్బిట్రల్ ట్రిబ్యునల్ ముందు వెళ్ళి మీరు చెప్తున్నారో దాన్ని బేస్ చేసుకొని అవార్డు పాస్ చేయాలి. The normal rule is the courts cannot go out of the issues. Once court will frame the issues, whenever you are going and filing the suit, what the courts will do, it will frame certain issues based upon your claim. It will frame certain issues. The court has to adjudge only these issues only. Likewise, when you go to the arbitral tribunal also, the arbitral tribunal has to pass an award by entirely ascertaining your claims only. They cannot go out of the ambit. If you are submitting 10 claims, they have to pass an award on these 10 claims. Right. Now, assume that you have raised 10 disputes between the arbitral tribunal and the arbitral tribunal has passed an award. Right. Now, after getting and seeing the award, you come to notice that 2 disputes have not been settled. Out of 10 you have asked, they have settled all the claims 8, they left over 2 claims. దాని మీద వాళ్ళు ఏమి చెప్పలేదు. Now, after getting the award and within 30 days, you have to file an application to the arbitral tribunal that this claim has been omitted by the tribunal. ఎందుకు చెప్పండి within 30 days? 30 days తర్వాత ఈ అవార్డు ఏదవుతుంది? It will become a decree. So after getting the award, what you are going to do? Within 30 days, file an application before the arbitral tribunal telling that these 2 issues has not been solved. Right. After receiving the application, then within 60 days, arbitral tribunal will process an additional award in respect of the 2 claims. Now, the additional award becomes part of the main award. You understand? Without issues alone clear again, what you are going to do? You are going and filing one application before the arbitral tribunal. You know why? Once award has been passed, the mandate of the arbitral tribunal ends. Again, you are filing an application. 2 issues you have not resolved within 30 days. After receiving the application, within 60 days, an additional award has to be passed. Again, straight away, merely by receiving an application, additional award cannot be passed. Application వచ్చింది కదా అని చెప్పేసి additional award pass చేయడానికి కుదరదు. Definitely, they have to go through the agreement. There should be no contrary provisions in the agreement referring the parties to the arbitration. You understand? The entire arbitration commences based on the agreement between the parties. So, in the agreement, there should not be any contrary provisions in the agreement. Second one is, we have to issue notice to the other party telling that these 2 claims has not been resolved. I am approaching the arbitral tribunal for an additional award. If you don't issue notice to the other party and if you straight away go to the arbitral tribunal, it is a procedural infirmity and it is non-est in the eyes of the law. Right. Third one is it should be made within application should request or application should be made within 30 days from the receipt of the arbitral award. Within 30 days to receipt of the arbitral award, you have to make a request or application. Right. Now within 60 days from the receipt of request, the arbitral tribunal will process an additional award. Additional award becomes part of the final award. Right. Now, next fourth type of thing is which? Consent award or agreed award. Consent award or agreed award. Right. Now, you went to the arbitration, file a arbitration application. So, maximum even the arbitration is nothing but a compromise. It's nothing but a compromise. Here, after filing the statement of claim and defense, if the both parties are willing for compromise, even without going into merits of the case, the arbitral tribunal may resort to mediation, conciliation, negotiation, and they will make the parties to come to a consensus. Right? Application file చేసిన తర్వాత both parties ఏం చెప్తారు? We go for a compromise decree. For example, in Hindu Marriage Act, if you want to file for divorce, which section? 13B, mutual consent. If you see the decree for mutual consent, there won't be any things will be there. Only 3 lines decree will be passed. There are differences between the parties. Hence, decree marriage has been annulled. Now onwards, they are no longer wife and husband. అర్థమైందా? For example, wife went to the court filing a divorce decree. The husband was involved in adultery. Right. Now, husband says no. Now what happens? Trial will go on. You take either case, whether the wife involved in adultery or husband involved in adultery, both filed a case for divorce. Trials will go on. In the trials, what happens? They will examine, cross-examine, re-examine, so many things will come. So now they will discuss everything. Whatever be the things you have been participated, they will discuss. These are the things. These are the evidences. These are the photos. These are the videos. Everything. They will discuss everything. Then subsequently, divorce will be granted. Now, husband says to wife, "We will go for mutual consent." So, if wife also agrees, they file an application before the courts for divorce for mutual consent. They don't discuss anything. They don't discuss any illegality of the husband, and simply they say indifferences arise, hence marriage is annulled. Now they are no longer wife and husband. Simply that's it. Here also consent or agreed upon, they will go. For example, we have to pay 10 lakhs to A. A went and file arbitration application. Then A and B comes to a compromise. B tells to A, I will pay 3 lakh rupees. Then A says, if A accepts, they both file an application before the arbitrator. Now, once the consent terms and agreement, that is terms and conditions have been accepted upon, arbitrator process and consent award. It is also deemed to be a decree. Understand? Next type of thing is default award. It is equated like a ex parte decree in civil suits. Default award. Ex parte decree எப்படி pass பண்றோம்? That is ex parte decree. Here it is known as default award. Right. Now, if any one party fails to participate in the arbitration proceedings, either the claimant or respondent, what happens? The arbitral tribunal, in the absence of that party, it will gives an award that is known as default award. By default, that one party has absent. Now I am giving the award. It is known as default award. It is equated to ex parte award. So we have seen once an award has been made, two things will happen. One is mandate of the arbitral tribunal will yes. Second one is res judicata effect will come into picture. This award is nothing but equated to a deemed decree under the civil procedure code. 5 types of decrees has been recognized. One is final award. Second one is interim or partial award. Third one is additional award. Fourth one is consent award or agreed award. Fifth one is default award. Next class we will see contents of arbitration agreement. Next one is challenging procedures. How you are going to challenge the award under section 34 of the arbitration conciliation act. Right? Got something today? Right. Good afternoon, class. Still 5 minutes to start. So today is our topic is about criminal justice system. What is criminal justice? It is a procedure where the criminal act, that means criminal conduct, is investigated, tried, inquired, and come to a conclusion with a punishment. That is the criminal justice system. So basically, in criminal justice system, to bring it to the conclusion, a law enforcement agency to give judgment or to adjudicate that thing, court is there to help court, bar is there, and after getting the punishment, when the persons or the accused is leaving correctional home or jail imprisonment, that is justice. So then this is the criminal justice. When a criminal given a justice or a victim given the justice. Now what is the system? That whole procedure, whole system where criminal is apprehended, tried, and give punishment. That is the criminal justice system. That whole procedure or whole system of giving punishment to a criminal is the criminal justice system. So what are the main component of this system? First, law enforcing agencies. Basically, the police. Second, the courts. Third, prostitution. Fifth, defense. Policing, court, prostitution, defense, then correctional home or jail. Jail. Law enforcing agencies. Basically, we said it, police. So, a criminal or a victim meet to the police first. Start this whole total system. That's why in FIR, you might have go for that sentence. FIR is the report who started the whole system. Where you FIR is going to give to the police, or when police start to investigate when something happened before him, or when he met to the accused. That is our policing system or law enforcing system. Not only police, there are too many other departments who initiate this criminal justice, like our enforcement directorate, national crime, our NID, then CID, CPID. Those are the systems who comes under this policing or law enforcing agencies. Okay, so it is the first one where how this or the criminal justice system initiated from the policing or law enforcing agency. Second, court. After all the thing done by the police, basically what is it? Investigation. Then he sent it to court. Why? For the proper trial. So in court, this adjudication is happened. But which court? In India, the highest court is Supreme Court. Next, if you go to section 6, it started like besides High Court, there are sections court, Judicial Magistrate first class, Judicial Magistrate second class, Metropolitan Magistrate, and Executive Magistrate. And section 6 of CRPC. So basically, these courts, according to the gravity and the nature of the offense, if different offenses go to different courts. What is the main issue, main motto of the court? First, adjudicate the issues. What is the issue? In CPC order 14, what is the issue? Any material proposition asserted by one party denied by other is the issue. Section 14, Rule 304, please check it. Same thing given as a definition in evidence, section 3. So there it says any nature, extent of any right, liability or disability asserted by one party denied by other, which is aroused from a fact or in connection of any other fact, is an issue. So in section 3, issue written as means and includes any fact or any fact arising from in connection with other facts of any nature, extent of any right, liability or disability asserted or denied in a suit herein follows. The definition, proper wording of the section 3. That is the issue, and the court has the duty to adjudicate that issue. Basically, the issues are the questions or the claims, which is I claimed it, you denied it. Yes or no? That is the issue, and the court has the duty to adjudicate this thing. Then, to help for this adjudication, there are two methods. One for prosecution, section 24 of CRPC, 24, 25 and 25A. Public prosecutor, assistant public prosecutor, and 25A, Directorate of Prosecution. Is the provision for these things are given under 24, 25 and 25A of CRPC. So there from the victim side, when it is a criminal case is instituted by affair, by nothing an affair. A criminal case can be initiated in two ways. Yes or no? One, by affair, by complaint case. 200, section 200. Can anybody say where in under which provision of CRPC the definition of affair is given? Those who says 154, it is incorrect answer. In CRPC, affair is not defined but discussed under section 154. Okay, remember this thing. It is not defined in CRPC, it is only discussed. So, in criminal case can be initiated in two ways, one by affair, one by complaint case. When you initiate the case by affair, a government advocate or public prosecutor or assistant public prosecutor is there to conduct your case in the court. So you don't need to get any other advocate to conduct your case. That does not mean that you cannot engage a private advocate to conduct your case. In 24, gives a right to engage a private advocate, but he has to assist the public prosecutor or assistant public prosecutor in that case. So, what is the criteria to appoint public prosecutor or assistant public prosecutor? We are not going to it. We have already discussed. Second party, upon whom you file the case, defense or the accused, he has to give a advocate to conduct his case. But still, the provisions of government advocate is there. When the accused is not financially so sound to engage a advocate, in that case, government give him a advocate to conduct that case. So, under section 301 CRPC, the provision for the Defense Council is given. What he has to do, basically what he has to do, he has to represent the accused or give defenses for the accused in the court to prove him not guilty for that offense. Last one, correctional home. That means jail, imprisonment, or whatever, prison, whatever you can say. So, after the case is concluded, that means judgment is passed and judgment is passed against the accused. That means, as we have discussed in IPC, punishment is there, punishment for imprisonment, punishment for fine. So when there is imprisonment, the accused sent to that correctional home or imprisonment or the jail. But there are certain category of persons like juveniles where they have to send. Can they be sent to the jail? No, because in that environment they might become a hardened criminal as their sentiments. So they are sent to the correctional homes where they might reform themselves what they have did. Let a kid who steals for only for his food, if you send him to the jail, he might become a hardened criminal because now he has no fear to the consequence of his act. But if in that case, if he is sent to a correctional home where he gets proper education, proper training, how to live outside in the society, or where he gets a lesson for what he is doing is wrongful and he has a repentance for that thing, he might change. That's why the juveniles sent to the correctional homes. But yes, there are some amendments after the 2013 amendments. They are treated as an adult and sent to the jail. But that is the exceptional cases. But in general, adults sent to the jail, these kids sent to the correctional homes. So these are our elements of the judicial system or criminal justice system. As one part of this system and very important part is policing. We need to learn about it or discuss about it. But as usual, I said, whenever we should go to a particular system or we have to deal with someone, we need to know what is his background, what is his history. So, what is the history of the police? Who can say what is the history of police? From when it is introduced, or at what time the policing system is there in India or in world? This is the point of discussion. First, let's go to the England, because we thought that our every law, every system which is now prevailing in India is coming from England. Let's first go to there. So nearly 1285 in Westminster, a province of this London. So those who are that what you call it, Jamindar type of that land, lots of that provinces, they started for their protection a group, huh? Westministers, a provinces of the London, 1285. Yes. So at that time, the policing system was introduced for the protection of the lot of that provinces. So some crowd controlling and that law and order maintenance, they used that road. Continuing after that, during 18th century, other things, other provinces also included or introduced this system for their own protection and control, law and order maintenance in their provinces. But there is a minister, prime minister, that Robert Peel. I think you have heard this name in Insanity 84 of IPC. That a person comes to kill Robert Peel, but he killed his private secretary. So that Robert Peel introduced a proper policing system in England. What are their jobs? To protect the dignitaries, king, queen, or other duchess, whoever there is in a professional situation or in that type of people, to protect them, to maintain the law and order, and to investigate the crimes that they created it. This is the story of London or Britishers. And from there, a proper policing system from goes to US and comes to India also. That's Police Act 1861 introduced by the Britishers. But the question is whether this policing system was comes only after British to India. No, because if you go through that Arthashastra, there is proper policing system in Mauryan dynasty. Who is totally Chanakya? Other name is Chanakya. Yes. In his book Arthashastra, some BC, I don't remember that proper timing. Some BC, it is introduced or he has written down this Arthashastra for the Mauryan Empire. Chandragupta Maurya, Samudragupta, that Ashoka, the dynasty is like that. So for him, he written down the policing system. Not only the Mauryan Empire, prior to him, Gupta dynasty, which is known as the golden era of the Indian history. There is also a proper policing system which is known as Dandakirani. Later on, the term changed to Kotwal. Then Mughals come. They introduce also they inherit that policing system. They told that the head as the Nizam and after subordinates they are Kotwals. Basically, Kotwals like that. Policing system. So it is not the Britishers who bring the policing system to India. It is prior to that. It is before prevailing here in India from the Gupta dynasties. Gupta dynasty, Mauryan dynasty, then Mughal. And that is the policing system. But in India, the army and police are not divided. It is not a two different departments. The whole department is one, and it is controlled by one person, that general or that Dandanathari, the same person. At the time of war, that policing system becomes the army. At this time, they become the policing and they do their usual job like crime controlling, investigating, and other things. What is their job? It is not the Britishers who bring this policing system to India. So after Britishers comes, like after Britishers comes, these things happen. So what are their system of managing this, investigating or law and order system, to maintain the law and order system, to protect the high level officials? How this happened? It is on the zamindars, because at that time our system was, the British system was mainly based on the zamindars. So this policing system is also controlled by them, by zamindars. But after that land reforms, when zamindars were eradicated, or here oligarchs are there in Andhra or this region, oligarchs. So they are also eradicated, that no, we don't trust this system, we need our own system, land system and tax collection system. We don't need zamindars or oligarchs. In North India, there are mahalas. So this system was eradicated or stopped. So this policing system comes to their control directly. But at that time, the problem is same problem as we discussed earlier, corruption. So who are the police? He becomes the thief. He becomes the investigating agency. So sometimes at that time it is becomes more complicated, or the proper criminal investigation is becomes difficult for this system of this corruption, because those who are the police, they are engrossed in the crimes and they come to investigate that same crime. So what is the result? We everybody know. So this is basically the history of police. So the word police comes from policia, which means the state or the administration, and that administration is come from, if goes to Britishers, it is from 1285 this system was introduced. If come to India, it is there from Mauryan or Gupta dynasty. From that time it is prevailing. After that a proper policing system come in 1861 by Police Act. So this is the whole story of our history of police. So nowadays, what are the category of police? General police, which include traffic police also, criminal investigation department, CID, ED, everything, CBI, IB. IB actually, it is for the internal investigations, that intelligence department. As raw for outside, IB for inside. Spy agents, basically those two are spy agencies. We don't included that thing here. After that, railway police was there, military police was there, ITBP, Indo-Tibetan Border Police Force. That is also a department of police. CRPF, that is also a department of police. So, what is the principle of all departments or the whole system of policing? What is their motto? What is their objective? Protect the people. First, strengthening the security of not only the persons but also the property. Second, maintaining the law and order, as our sirs and madams are doing to maintain that law and order in between you, and which you are not following. Third one, to protect the rights of the persons, freedom, liberty, life, everything, to protect that thing. Second, prevention of crime or any disorderliness. Next, to investigate that crime or that disorderliness. So these are some important objectives of the system of policing or policing system. These are our objective of the police system. But the main questions always come: does it work out effectively? Does this policing system is working properly? Sometimes yes, sometimes no. Why it is not working properly? Huh? Corruption everywhere. This is the first cause not to do their duty. Second, misuse of power. I am in power, I am misusing that power, as we have discussed in professional criminalism. Yes or no? Shortage of staff. What are the proper criminal investigation or proper law and order and maintenance? What is the amount of police officers needed for a particular place? It is not there. Political interference. If some other powerful person is involved in a crime, they influences the government and there creates an interference over that proper investigation of that thing. Then lack of training or lack of up-to-date of the system. Now this cyber crime is happening. Does the proper training is given to this police officers? No. Still, if you go to the police station, still they using some Windows XP or Windows 7, but system upgraded to Windows 11. Still they are in i3 core processor. So not only that proper training, but infrastructure is also a main cause of failure of this policing system. So this is all about your policing history, policing system. Next time we are going to discuss about mode of recruitment of the police, by which a person can be a police, become a police, like from constable level, ASI level, IPS level. Yes or no? That is the recruitment of the policing system. And other ways. How, and next one is how the investigation, what is the proper channelization or way, procedure of that investigation, that is the chapter or subject of discussion for the next class. So for today, this is all. Thank you and have a good day. So please pay attention. All 3 years and 5 years general students are requested to assemble in the fourth floor after lunch. Attendance will be taken there. Yes, after lunch. For now, Abhijit, I don't have list. Students, please listen. All 3 year LLB as well as 5 year LLB and BBA and BCom LLB students. You are requested to assemble in the fourth floor, not now. When you come in the afternoon sessions, you need not come to auditorium. I repeat, 3 year LLB without honors, 3 year LLB, 5 year LLB, BBA and BCom. Okay, honor students has to come to auditorium. You all have to come to auditorium. Honor students. General students need to occupy fourth floor. They will take your attendance there when you come inside. Okay. So need not come to auditorium. Am I clear? Now girls, like yesterday, please leave. Same room. Row wise you leave. I repeat again. 3 year LLB. You have to give your attendance here. 5 year general courses room number 242. Now 42.
Please manage. I told you another time, God should not stay there. One day more means they need to leave here. Boys also please. BA LLB 4-2, BA LLB honors 4-5, BBA BCom 4-7. Rest be here. Your attendance will be taken here. Boys, please occupy this side. Sit down, please. Let us start taking your attendance. Please take your seat. Unless until you sit down, we will not take your attendance. Last bench, please come forward. Show us to sir. Tell them, sir. Unless boys, please listen. Unless until your turn comes, please don't stand up. Okay. Let us behave civilized. You are occupied, so, sorry, you are all 3-year honors. 3-year general as well as honors. 3-year general and 3-year honors.
General. Deposit class.
If you wanted to leave early, come sit to the front row again in the morning. You people come late for the class and you want to leave the class early or what?
നമ്മളത് പൊട്ടന്മാരാ ഒരു മര്യാദ വേണ്ടോ
3 years honors. 3 years honors. And more 2 years honors. No ID card, no attendance. Go, collect your ID card. Go, give us your ID card. So, please stop. Notice that. Good afternoon. Then I'm talking like I was in. So I was busy here. He is taking this. I will let you know. Okay. That is not there. That's where I'm going there. Just say it to me. Then I will discuss it. अब इसका आईडी कार्ड तो नहीं है, सब पे भूल गया है। ये उसका आईडी कार्ड नंबर हम भूल जाएंगे, हम भूल जाएंगे तुमको, हम भूल जाएंगे आईडी कार्ड। How you are coming without ID card, without dress code? ID card. Don't know. It's too much. Global Institute. Sir, you bring his ID card and see him. This time we will include. Who is this? See the blue. Yeah. You stand here and you stand there.
Where? यहीं पे? Ladies and gentlemen, now it is the time to disperse from here, and we all are assembled here to know one another, and so dear students, now यार भाई जल्दी करो भाई कितना बार बोलूंगा मैं। ये चेहरा भाई वाइट आना चाहिए। कहने का मतलब यही है, सबको कुछ ना कुछ सीखना पड़ेगा, एंड किसी को
लाइव चल रहा है ना ये?
बंद नहीं होगा अभी।